My name is Elizabeth Maricola, and I'm the Deputy Director here at Darien Library. Thank you for joining us tonight for the second event in our landmark President Series on Intellectual Freedom. The President of our board, Hutch Pegler, and our trustees welcome you to this series exploring some of the most pressing topics of our day: free expression, civil liberties, and the power of literature. Before we turn to tonight's program, please mark your calendars for the next event in our series on Wednesday, December 6th, a screening of the documentary Judy Blume Forever. You may not know that beloved children's book author Judy Blume is among the most banned authors in American history. And finally, we are thrilled to announce tonight for the first time ever that Floyd Abrams, the storied attorney who has argued for the First Amendment before the Supreme Court 13 times since the 1970s, will be the guest speaker at our concluding event on Wednesday, January 24th at 7 p.m., and we look forward to seeing you all there. Tonight, we welcome Beau Breslin. Beau Breslin is the Joseph C. Palamountain Jr. Professor of Government at Skidmore College in Saratoga Springs, New York. He holds a PhD in Constitutional Theory and American Politics from the University of Pennsylvania and a BA from Hobart College. He has written extensively on the U.S. Constitution, the right to free expression, and the death penalty. His latest book, A Constitution for the Living, Imagining How 5 Generations of Americans Would Rewrite the Nation's Fundamental Law, has won several awards. He is currently working on a monograph that considers what was lost when critical sections of America's founding-era documents were edited and redacted because of political sensitivities. This evening, Beau will be addressing the concerning issue, does America have a free speech problem? Please join me in welcoming Beau Breslin.
Thank you so much. Thank you to Elizabeth. Thank you to Pat for inviting me. It's great to be in Darien. I can't be more excited about tonight. I'm going to talk for about 30 minutes, no more, and then Elizabeth and I will talk about questions. Does America have a free speech problem? I think the answer is maybe, and I'll have a lot more to say on this. I'm going to go quickly through a few things and then get to the kind of contemporary era. Okay. So the answer is probably maybe the United States has a free speech problem, but the New York Times seems to think so, right? This is March 18th last year. The New York Times editorial board said that the political left and right are caught in a destructive loop of condemnation and recrimination around cancel culture. Many on the left refuse to acknowledge that cancel culture exists at all, believing that those who complain about it are offering cover for bigots and peddle hate speech. Many on the right, for all their braying about cancel culture, have embraced an even more extreme version of censoriousness as a bulwark against a rapidly changing society with laws that would ban books, stifle teachers, and discourage open discussion in the classrooms. That's what we're going to talk about today. And what we're going to do is we're going to start by how did we get here, right? So the First Amendment is an anchor right. It's an anchor set of liberties in the United States. The Constitution. And how did we get here? Well, essentially, what happened was, we'll go back to late 18th century America, the Constitutional Convention. On September 12th, for the first time in 1787, the Constitutional Convention delegates talked about a Bill of Rights. It wasn't until that point, many of you know, that the Constitutional Convention starts in May, ends in September 17th. But it isn't until May 12th that they start to talk about a Bill of Rights. And George Mason is the one who decides to bring the conversation to the group on September 12th. And he says, you know, maybe we should have a Bill of Rights. And ultimately, they decided the answer was no, and there are reasons why the Constitutional Convention delegates, the James Madisons and the Ben Franklins and the Alexander Hamiltons of the world, decided not to have a Bill of Rights. So on September 17th, when the Constitution becomes public, it has only the original 7 articles. You can get your Constitution out in the lobby. Apparently there's a bunch of them. Get one as you leave. But the original 7 articles are what comes out in September 17th with no Bill of Rights. Anti-federalists, those who oppose ratification of the Constitution, cry foul. Why not a Bill of Rights? And the reason is This is from Federalist 84, the Federalist Papers. Alexander Hamilton wrote the reason why the delegates did not want a Bill of Rights. And the reason is, this is Hamilton's wording, the Constitution is itself in every rational sense and to every useful purpose a Bill of Rights. And what he meant by that is fascinating theoretical argument. That a constitution, a written constitution, granting powers to particular institutions of government cannot abridge freedoms of individuals if the powers are not written into the Constitution in the first place. The Constitution does not give Congress the authority to abridge freedom of speech, for example. And so Hamilton said, having a Bill of Rights is redundant. You don't have to have a Bill of Rights. It's repetitive. It's unnecessary. And in fact, Hamilton is famous for saying that having a Bill of Rights, adding a Bill of Rights is actually dangerous. And the reason why it's dangerous is because whatever's written in a Bill of Rights, whatever rights are enumerated or embedded in a Bill of Rights, will become the entirety of the Bill of Rights, and there won't be any additions, Hamilton said. Fast forward to the 21st century, or the 20th century, and you see that there's a right of privacy not written into the Constitution. There is deep controversy about that. Hamilton says, see, I told you so. Ultimately, it's dangerous to write down a Bill of Rights. Anti-Federalists still said, no, we want that insurance. And so Madison proposes amendments to the Constitution on September 25th, 1789. He originally, this is Madison, he's a Congress member. Madison originally proposed 19 amendments. Congress consolidates and trims a little bit, and 12 of those 19 amendments are passed by Congress. Any of you have been to, little footnote, and I'll always tell these little anecdotes, any of you have been to the National Archives and gone in to see the Constitution, the Bill of Rights, and the Declaration of Independence, everybody beelines for the Declaration of Independence. But the Constitution and the Bill of Rights, the original written Constitution and the original, Madison's original Bill of Rights, are right there for everybody to see. You can see all 19 of his proposed amendments, and it's amazing to see that document. So Congress trims and consolidates. 12 are passed by Congress, and of those 12, 10 are ratified by the states. Our Bill of Rights says 10. The two that were not ratified by the states, one dealt with apportionment, number of Congress members per state, and the other one dealt with pay raises for Congress members that eventually becomes the 27th Amendment in 1992. So it only took 200 some odd years for that that amendment to be ratified. What is interesting, and what I tell my students, right, so you see here, Congress shall make no law, this is the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press. That's what we're going to talk about. It's not emphasized in the Constitution. Or the right of the people peaceably to assemble and to petition the government for redress of grievances. That First Amendment was Madison's third. People will tell you over and over again that the First Amendment is kind of the anchor. It's kind of the first among equals of the Bill of Rights. It's the greatest of all equals, because greatest of all rights, because it has the right to free speech and so on, freedom of religion. But Madison put it third. It's just that the first and the second one did not get through Congress, so now it becomes our First Amendment. It was not the most important for Madison. Others were more important. That said, the First Amendment, especially the freedom of speech section of the First Amendment, is meant to do two things in the late 18th century. It's meant to prohibit prior restraint and licensing. This is from the British common law. Newspapers had to be licensed, and that as a result, they could be censored. And the First Amendment is supposed to prohibit or protect against that. It's also supposed to protect against seditious libel, right? So people can say whatever they want against government, and the First Amendment is supposed to protect their speech. So why do we have it, right? So philosophically, the power of the power of free expression is really, most people will boil it down to four different things, right? Four different positive aspects of free expression. And it advances knowledge and truth, right? The ability to speak one's mind and enter the marketplace of ideas and have your ideas batted around is a effective method for getting to truth. Two, it facilitates representative democracy, right? We have to have free speech in order to be good citizens of the polity. Three, it promotes individual dignity, self-expression, courage, and autonomy. If we have the power to freely express ourselves, we often will generate a certain amount of courage getting out there. I always tell my students the First Amendment is the right to free speech is a powerful, powerful tool. Most of you will never need it, right? Because it protects those who speak topics and issues that we largely despise, and we'll talk about those in a second. But it also is incredibly important to have the backing of the right to free speech so that you can have the courage to say what you want to say, and it builds self-expression and autonomy. And it's also a weapon to keep public officials accountable. Our ability to speak freely helps us to keep our public officials accountable. I've given you a couple of quotes. I won't read them, but I will say to you, in the 20th century, Justice Oliver Wendell Holmes, who we'll talk about in a second, is probably the most famous advocate of the right to free speech. But I would argue that Justice Brandeis was the greatest defender on the court. There have been other, John Stuart Mill and others, but on the court, Louis Brandeis was the greatest defender of the right to free speech. Okay, so let's do a quick tour through America's Supreme Court rulings on the right to free speech. My students are surprised when I tell them really the first constitutional arguments or constitutional cases dealing with the right to free speech come out of the First World War. There are some cases that are in the 19th century, but they're very few. It isn't until the First World War that we start to have these great Supreme Court cases dealing with free speech, and from roughly 1919 till today, it has been quite a journey, the right to free speech. But the first real meaty free speech cases in this country, outside of the Alien and Sedition Act, come as a result of the First World War. And they are aimed at prohibiting incitement to violence and incitement to, and give me a second, I'll show you a couple things. There we go. Okay, so in 1919, there was a super famous and important case called Schenck versus the United States. Charles Schenck is a socialist. He believes in that the draft for individuals to enter the armed forces is a violation of the 13th Amendment prohibition against involuntary servitude. And so he shows up with leaflets. He's got a partner. He shows up to a draft board, essentially an office that's enlisting Army soldiers. And he starts handing out the leaflets saying, get out of line, this is a violation of your 13th Amendment prohibition against involuntary servitude. And he gets convicted of violating the Espionage Act of 1917. So he takes his case all the way up to the Supreme Court, and the Supreme Court has to decide whether or not that leaflet and his distribution of that leaflet is protected by the First Amendment right to free speech. And the court says no, right? And the reason the court says no, in an opinion, a famous opinion by Oliver Wendell Holmes, is that the Times, 1919, we're dealing with the First World War when he was handing out these leaflets, the Times demand a little bit more censorship, right? Oliver Wendell Holmes famously said you have to take the context of the moment in account when you decide whether or not the speech will be protected. So, for example, Oliver Wendell Holmes said, nobody would say that falsely shouting fire in a crowded theater and causing a panic is protected by the First Amendment. That's what Oliver Wendell Holmes says. And so what becomes, this line of First Amendment adjudication becomes known as the clear and present danger test. And what Oliver Wendell Holmes, who writes most of these opinions at this time, is saying is that the moment will dictate whether or not the speech will be protected. In World War, we need to kind of tamp down speech, so Mr. Schenk's pamphlet is not protected. He gets fined, he goes to jail, whatever happens to him. 6 months later, there are 3 cases. Schenck versus the United States, there's a case with Eugene V. Debs, and there's a case where the plaintiff is a guy named Brower. These 3 cases happen within a week or 2 period, and the court over and over again says, because of the context of the time, we're not going to protect the speech. The First Amendment, right to free speech, does not protect these inciters. Okay? 6 months later, Holmes has a change of heart. And that 6 months later, in a case, U.S. versus Abrams, that case changes the fundamental nature of the right to free speech. Now, what happened in that 6-month period so that Oliver Wendell Holmes goes from essentially very limited protection of the right to free speech to very broad protection of the right to free speech? There are stories out there that suggest, A, he had an epiphany that this was not what he wanted for the right to free speech. 2, he had a friend who was a guy named Learned Hand, who was on the Court of Appeals at the time, who talked him out of this restrictive free speech approach. I like the third story because, and there's some thought that this third story is real, that Louis Brandeis went over to his house and said, Ollie, come on, we need to protect the right to free speech. I do believe Oliver Wendell Holmes, folk hero, he's one of the great Supreme Court justices of all time, one of the great liberal justices of all time. He was a totally cantankerous, egotistical, just kind of a nasty dude. And the only person really on the court that he fully respected was Louis Brandeis. So Brandeis goes, this is the story that I tell myself, there's some truth to it. Brandeis goes and talks Oliver Wendell Holmes out of being so restrictive of the right to free speech, so that 6 months later, when cases come up dealing with the First Amendment again, Oliver Wendell Holmes switches his vote and starts to uphold the speech as protected by the First Amendment. That happens, and so there's a whole line of cases, clear and present danger test. Historically, though, over the course of the 20th century, there's this other area of free speech that's also fascinating. We're moving out of the clear and present danger, incitement to violence area to what in the First Amendment adjudication they call these categories of speech. And I won't go through all of them because I've got to make sure that we have plenty of time for questions. But let me go through a couple of them. So this all starts with a very famous case out of New Hampshire called Czaplinski versus New Hampshire. Now what happens is Mr. Czaplinski is a Jehovah's Witness. And Mr. Czaplinski is essentially told that he needs to move, he's going to get shut down, and he's so angry at the marshal, the police officer, who's shutting him down, that he calls him a goddamn racketeer, right? And at that time, that was quite the insult. Nowadays, not so much, but at the time, that was quite the insult. And so the court has to decide whether or not his goddamn racketeer should be protected speech. And what the court decides is that there are certain categories of speech that fall below the protected line and will never be protected. Certain categories of speech are not worthy enough to be protected by the First Amendment. fighting words, like Mr. Chaplinsky, goddamn racketeer, libel, profanity, obscenity are the four that the court says are so not valued, so disrespected that they fall below the line and the First Amendment will not protect them. Okay? So again, fighting words, libel, profanity, and obscenity. Here's the takeaway from today's lecture talk. The story of the First Amendment is a story of each of these being more or less protected now. Right? It is a story of the expansion from 1942 when Chaplinsky has decided, the story of the expansion of the right to free speech so that all of these things more or less are protected now. In the beginning, 1942, not so much. Nowadays, huge protection of the right to free speech. Okay? And we can talk about any of them. I'm going to talk a tiny bit about hate speech. Hate speech was not one of the categories of speech in Chaplinsky that Justice Murphy decides in Chaplinsky. But hate speech is a very prominent part of our current political arena. So, very famous case in 1992, R.A.B. R.A.B. is a minor, that's why we only have his initials. He thinks it's funny to burn a cross on a black family's lawn in Minnesota in violation of a Minnesota law, St. Paul law, that says you cannot Nazi swastikas or burn crosses in violation of this particular ordinance. He decides he's going to be funny, he decides to burn a cross, and the question for the court is whether or not his burning of the cross is constitutionally protected. Now, I always tell my students that at the end of the day, RAP's got other problems, right? He's got pay for damage and all that kind of stuff. That's not what the First Amendment protects. But his speech is absolutely protected, and the court protects that speech as political speech. Very famous. Symbolic speech, the last one, Texas versus Johnson. Mr. Johnson burns a flag. The court has to decide whether or not his burning of the flag violates the Texas law prohibiting that, and the court says yes. We are going to allow burning of the flag. And in fact, Justice Brennan says there's no greater demonstration of civil liberties and the freedoms that the founders and the revolution fought for than the ability to criticize your government by burning the flag. It's a very famous decision. Okay, moving on. Nowadays, there's all sorts of new First Amendment stuff that's real super exciting. First Amendment in the technological world. So some of the cases that the court has to deal with are very complicated and very contemporary, like computer-generated imagery. Ashcroft versus Free Speech Coalition in 2002 is a case in which the court has to consider whether or not the Child Pornography Prevention Act, CPPA, is constitutional, because that Child Pornography Prevention Act prohibits the individuals from computer-generating child pornography, not real child pornography, but computer-generated images of child pornography. And the court says, yes, that we're going to protect that speech. So it is computer-generated child pornography is protected. That's saying something about the power of the First Amendment, because there's probably no greater violation of decency than child pornography, and yet the First Amendment is going to protect computer images. It's never going to protect actual child pornography, but computer images of it, absolutely. Knight, First Amendment, Institute of Columbia versus Trump. This is when Trump banned 7 people who were criticizing him on what was at that time called Twitter. The court said, you can't do this is a lower court, you can't do that. Your Twitter account, Mr. President, is a public forum, and you can't ban people from seeing your public forum. Video games, there was a law passed that prohibited minors from purchasing and playing video games that were violent. The court says protected by the First Amendment. Justice Scalia, the most conservative member of the court, protects that. Which brings us to book banning, right? And I'm aware of the the time. We've got about 5 or 6 more minutes. Let's talk about book banning, right? We are in a library. It is a very, very popular conversation at the moment in terms of the right to free speech and whether or not families and school districts and libraries and so on, they are deeply embedded and engrossed in this particular conversation. You have laws that have been passed that more or less allow for books to be removed from classrooms and libraries, right? The ones in Florida, there's one in Missouri, Utah Sensitive Materials in Schools Act. This is all this web of trying to figure out what is acceptable books in libraries and how much role of parents have in the education of their youngsters. Some of the interesting data, according to the American Library Association 2023 report, there have been 695 attempts just this year to censor materials, accounting for 1,915 unique titles that have been tried to either challenged or banned. This represents a 20% rise from last year. So the issue is becoming more and more part of the mainstream. Most of the books that are either challenged or being banned are about race, sex, and LGBTQ plus themes. And 49%, this I thought was amazing, 49% of these efforts are directed at public libraries. It used to be almost all of the conversation was about schools and their libraries. Now, roughly 1 in 2 challenges and bans are happening in the Darien Public Library and its sister libraries around the country. There are attempts to battle back, right? Illinois enacted the first law in the country that outlaws book banning. Any school or library that bans any books forfeits all its state funding. Federal judge in Austin, Texas found that the library board violated the First Amendment by removing books it deemed inappropriate. There's a quote from that federal court judge, it was the district court judge. Several suits in Florida, Texas, and other states alleging violation of the First Amendment for the removal of library books. So what's being geared up is, and this is why Mr. Abrams will be fantastic for you in January, what's being geared up are the litigation, are the lawsuits about some of this book banning. It's really a topic. And the Supreme Court had something to say about it, if you can believe it, right? In 1982, way before the current era, there was this case takes place on Long Island, where a local school board removed several books from the district's library. As I said, including those by Richard Wright and Kurt Vonnegut. The school board claimed the books were anti-American, anti-Christian, anti-Semitic, and just plain filthy, right? And what happened was, this is part of the reason why we're in the predicament we are in now. What happened was the court was deeply divided about it. And I think the reason why, if you read the opinion, Justice Brennan writes for a 4-person plurality. He gets a 5th vote, but it's a 5th vote just based on procedural stuff, not on the merits. So it's a little more complicated, not worth our time. But the problem is the court was conflicted. The court was conflicted even though the First Amendment right to free speech and the prospect of banning books was seen as just egregious violation for the Brennans, the liberals of the world, on the court. But they were conflicted because obviously we're talking about a local school board, and the court has regularly said in other cases that localities have control over their own educational systems, right? So there was this kind of tension about, well, the First Amendment should protect against banning books or removing books from the library, especially the Kurt Vonnegut's of the world, but we want to make sure that local school boards still have autonomy to decide what they want. So this is the Justice Brennan writes, local school boards have broad discretion in the management of school affairs, but their decision must be exercised in a manner that comports with the transcendent imperatives of the First Amendment. That sentence suggests to you that there is a tension there. The court anticipated this conversation about book banning. The problem is they didn't give us all that much guidance. when we in 2023 to figure it out. So, does America have a free speech problem? You know, the answer is probably yes. America has a free speech problem. I come from a higher ed institution where it's not easy to say things that people want to say, right? Students are quick to condemn each other and faculty and so on. But even outside of the educational environment, I think we're in a bit of a dicey moment here when it comes to the right to free speech. So what's at stake? This is that same New York Times editorial. Free speech today demands a greater willingness, perhaps at any other time in American history, to engage in the ideas we dislike and a greater self-restraint in the face of words that challenge and even unsettle us. I think that's the best way to finish up what we have today and get to your questions, because I'm sure you want to engage in conversation with us.
Okay, so I guess while we're waiting for everyone to write their questions, my first question to you is, why do you think now, 40 years after that 1982 case, we are seeing so much of the same conversation happening? Is it cyclical? Is it like a cycle we're never going to escape from? Is it like, what do you think is the driving force behind what's happening right now with the First Amendment?
I mean, I think there's a lot of, it's a great question. I think there's a lot of reasons that are all interconnected. So people talk about the tribalism of our current political landscape. I think that's part of the reason why we're in the situation we're in. You know, I'm 57 years old, and I can't remember a time in which we were as polarized as we are now across the country. And, you know, there's some interesting things to think about. One of the things that I always think is fascinating is we have tried so hard over the course of the 230 plus years that we've been in existence to think of ourselves as a United States, but we really are a lot of different countries all boiled down into one. So, you know, my father grew up in Selma, Alabama, and the way in which he saw the world was very different than I, who grew up in Rochester, New York. And so I just think there are a lot of different ways, a lot of different components, politically, socially, culturally, that have made this moment a tough moment. That's not a hopeful, that's not a positive answer, but I think there are ways in which we can get out of it, which we can talk about at some other time.
Well, that's a good second question.
That is a good second question. Actually, what do you think are the ways we can get out of it?
Well, I mean, so I think there are a couple of things, and I'm a political scientist, so I'm always gonna talk politics, right? I think there are ways, and let me preface this by saying, I love talking free speech, even quickly like we did today. My greatest joy is talking constitutional stuff. So if we're going to talk constitutional stuff, that's where I'm thrilled. And I do think our Constitution, as much as it changed the world, I think it needs an update, right? So one of the reasons why I think we're in the predicament we're in is because our Constitution, as great as it is, does not anticipate some of the problems we have. So, for example, I do believe we should have, instead of Supreme Court justices who have life tenure, let's have an 18-year term for Supreme Court justices. I think we should have term limits for Congress members. I think there are lots of ways in which we can make our 21st century politics better than what it currently is, but it might take significant amendments and reforms, and I'd love to see that. It's not going to happen in my lifetime, and that's a shame. 57. I don't see us having a constitutional convention in the next 15 years, unfortunately. Wouldn't that be great?
That would be. All right, so first question from the audience. When do you think that these issues, these lower court cases, are going to make it to the Supreme Court?
Yeah, so generally the average time that it takes to get to the Supreme Court is about 4 years. So, but I actually think, so this is an interesting moment, right? So you all are as savvy as anyone on the planet about what's going to happen at the Supreme Court. For the most part, I think the Supreme Court's going to duck these questions, right? This Supreme Court is both amazingly obvious and mysterious. So, for example, if we talk about arguably the two biggest cases that have been decided in the last 12 months or 15 months, Dobbs and the affirmative action cases out of Harvard and UNC, the court fundamentally changes, especially in the affirmative action cases, they move the goalposts. They do some things. Chief Justice Roberts writes the opinion in that case. They do some things that are utterly head scratchers, flummox. Even if you are conservative, he's very disingenuous in that moment, and we can talk about that some other time. Dobbs is an opinion, and I'll just give you one example. Dobbs is an opinion about abortion. I get it, right? But for an entire 2 generations, the right at stake in the abortion question is the right to privacy. There is no right to an abortion. Everybody knows that, including Samuel Alito. And yet you notice, if you read his opinion, not once does he talk about a right to privacy, because it would make it difficult for him to be able to say there's no constitutional right of privacy, because of course Griswold in your great state of Connecticut is where the right of privacy was embedded. So he has to manufacture this right to an abortion, and of course there's no right to an abortion, especially if you are an originalist. And I'm not going off on a tangent. My point is that this court is perplexing. So when it comes to book banning and the type of free speech stuff that's out of the political realm, we can talk about Citizens United, but out of the political realm, I think they're going to duck it for the most part. So even if a case comes up in 3 or 4 years, I don't think the court will take it for about a decade, if at all. Remember, 10,000 cases are essentially petitioned to the Supreme Court, 10,000, and they take about 60. So your odds are pretty low of getting your case argued before the court.
Are there any big cases pending before the current court that you recommend paying attention to?
Today, right? Today is a super interesting case. And quite frankly, this is another example. Maybe this is the takeaway, is your good friend Bo Breslin from Skidmore College is completely puzzled by this current Supreme Court. Today, the court heard an oral argument in U.S. versus Rahimi, the Second Amendment case. And most of you will have known this by now, but Rahimi is a kind of a nasty dude who has a gun, and his girlfriend gets a restraining order, and the congressional law prohibits him from having a gun if there's a restraining order against him. He argues it's a violation of the Second Amendment. And if you read the reports, the accounts out of Washington, it looks like the conservative justices are on the same side as the liberal justices and going to uphold the congressional legislation. That's not altogether surprising. It's not a real popular thing to say that somebody who has a record of abuse and assault can maintain a gun. But still, I'm still a little surprised that there wasn't a single justice who seemed to be receptive to Rahimi's side of the argument. So I think that's a really important case, is the Rahimi case.
Can you imagine a scenario where libel, profanity, hate speech, etc. go back to being unprotected speech?
No, I can't imagine a situation in which as conservative as this court is, and it is, I mean, there are 5.5 really. I don't consider Roberts a full conservative, but they're, fairly steady 6 votes for the conservative side. It is the one area, free speech is the one area in which the court has kind of doubled down on the right. Scalia writes the RAV opinion saying that even though the kids' behavior was disgusting, we have to uphold the right to free speech. So I don't think it's going to go back to a time in which maybe libel, although not the other ones. What I think is going to happen is with a lot of civil liberties, the court will chip away at those, like they've done in a couple of other places, like Miranda and so on. I don't see them overturning anything like they did in Dobbs with Roe versus Wade, but I see them chipping away at the broad right of free speech.
Can you talk more about how the ability to exercise free expression squares with hate speech, and like how hate speech is protected, if it is an incitement to violence or not?
So, I mean, a couple of things, right? If you have a chance, I'm not even going to encourage you to do it. Don't read RAV versus City of St. Paul. And the reason why, that's the main hate speech case. The reason why is because Justice Scalia's opinion is really convoluted. It makes zero sense. And I'm not saying that just because I'm moderately liberal and he's conservative. It's a very complicated, and he just kind of misses the point. That said, he still protects the right to free speech, so that's a good thing. How do I kind of justify hate speech? At the end of the day, I'm a super privileged guy, right? I'm a middle class, white, male, heterosexual, Christian-based religion. I am so privileged. That said, I do believe that the right to free speech is the most important right we have. And even though I will never need it because I'm so privileged, I recognize that the revolution was fought for us to have the liberty to be able to say things that we absolutely despise. And by that I mean things like shameful behavior on the part of RAV versus in that burning a cross on a black family's lawn. I even think shameful behavior on the part of Mr. Johnson in burning the flag in Dallas, Texas. Shameful behavior by the neo-Nazi group in Skokie, Illinois, marching down the center of Skokie, Illinois. All of that is shameful behavior, but I will go to my death to defend their right to do it.
Absolutely.
Right? And so, and ultimately, if we start to lose that, we start to lose what it means to be a free and open society.
So what do you think that we can do individually to help protect free expression of speech?
Wow. I think today is a very... Pat, did we pick today because it was election day, or did we just pick today?
Happy coincidence.
Here's the thing I tell my students. Elections matter, right? And it seems, I know I'm preaching to the choir here. You guys know what it is. But my 20-year-old and 21-year-old students do not get that elections matter. And in particular, all elections matter, but in particular, the presidential election matters because people are throwing, my students who are, the Skidmore's a liberal arts college, it's going to have predominantly liberal students. They're throwing up their hands and can't believe that President Trump was able to put 3 conservatives on the court. And I'm like, well, what did you expect, right? So how do we defend the right to free speech? Quite frankly, the best defense of the right to free speech beyond actually engaging in elections is to speak, right? Enter the marketplace of ideas. When you see something like a town next to you that's banning books, go to that town and actually say, what the hell are you doing, right? What are we so frightened about that we have to take some of these books off the shelf? What are we frightened about that critical race theory is something that we cannot expose our students to. What is the fear? That's the kind of thing. So vote and speak your mind. The best antidote to the type of censorship we have is to speak, speak, speak.
This is an interesting one. So, is there such a thing as misinformation, and how would you define it?
So yes, there is misinformation. And how would I define it? Oh, that's interesting. Well, I have to give that some thought. But misinformation is any information that I'm not going to say bends the truth, because in some ways, as a political science student, I'm a student of politics. I'm not involved in politics, but as a student of politics, all politicians bend the truth a little bit, right? So we can't sit there and say bending the truth, but intentional manipulation of the truth for a particular purpose strikes me as at least one category of misinformation. And what has become difficult, I think, in this day and age with social media, internet, and so on, is figuring out what is the intentional manipulation of the truth. Some of it is obvious, right? But other things that are a little bit on the margins are not always easy to understand that they're misinformation or disinformation. But I think the intentional manipulation of the truth to fulfill an agenda is probably as good of a place to start as any.
This is a related question from someone else. Can you discuss the issues that the deliberate spread of false information by high-profile figures have brought to our current climate?
Yeah, I think one of the reasons why you're all more educated than I am about this, but one of the reasons why I'm troubled by our current state of politics is, and I'll preface this by saying, I fear for democracy, but that's not a winning message for any politician. I fear for democracy. Right? Maybe Obama could have pulled that off. But our current political environment, if you stand up there and you say, I fear for democracy, people are just going to tune you out. What troubles me are things that are so blatantly obvious and so consistent with what was political tradition, right? We have some bad traditions in this country, and we ought not to follow them, especially with regard to things like race and so on. But when it comes to political tradition, the peaceful transition of power and so on, those things you've got to fight for, right? You've got to stand up and say, no, what happened on January 6th was not acceptable. It's not about whether or not Mike Pence is going to, is going to certify the election and so on. What happened on January 6th, for example, was not acceptable behavior. And so what I see and what's problematic for me is local, state, and national politicians who refuse to engage in the conversation about what was wrong with the last, say, decade of our political environment. Because they fear, this is why I want term limits, they fear the blowback that might end up losing their job. So ultimately, I think we ought to, in order to combat our current state of tribalism and so on, people need to have the courage to say, some stuff is just not acceptable. It's not cool in this particular environment. And I just don't see that, especially coming out of Washington.
Okay, so talking about technology and free speech, do social media platforms have the right to ban certain types of speech on their platforms?
The answer is yes. There has been at least one case that recently where the court had to deal with, these are the Googles and the Twitters and so on of the world have this deal that they are protected from liability for particular things and particular messages. And so the question about where we are 5 or 10 years from now and whether or not a social media outlet will have the ability to ban particular messages, that's an interesting question, and I'm not sure what the answer is. But currently now, yes, they can.
Are social media companies considered publishers?
Any lawyers in the group? No. I'm only a PhD. I don't have a law degree. If they start editing the content?
Because once they start editing their content, then they're actually selecting each scene and that strikes me as being a publisher.
Yeah.
Well,
Yeah.
I think there's law, I think there's a statute out there that exempts them.
No, pretty sorry to the.
Yeah. From the damages. Yeah.
Okay, how would the court view the decision not to bring a book into a school versus removing it, or into a library?
Oh, that's an interesting question. How do courts? If choices have to be made, right? There's only Elizabeth, you and Pat can tell us limited budget, right? So you have to make a choice. So the right to free speech does not require that every idea be in the marketplace of ideas. So I think the former, right, the decision not to bring a book in is part of the choice that libraries and school boards and so on and principals and teachers will make. But removing a book is a whole different ballgame, right? Because that's essentially shutting down that particular issue that's already in the marketplace of ideas. So I kind of see the idea of removing a book as this kind of censorship at the highest level, whereas deciding whether to bring a book in or not, I think is just a decision that has to be made by whoever's in charge.
So you touched on this briefly, but I love that this person wrote this question, and I think it's a good place for us to kind of wrap up our discussion as we're hitting our hour mark. Why is no one advocating for a constitutional convention if everything is broken and nothing is working? And also, what would that involve?
How much time do we have?
Give us the full answer. I want to know too.
Okay, so this is right in my wheelhouse. I love this conversation. Why? Well, let me first tell how, right? I'm going to start here because what the hell? I've got 4 minutes and I'm through. I'm totally a Madisonian guy, right? So which means James Madison is my constitutional hero. He's got some problems in other areas of his life, but he's my constitutional hero. And he and Jefferson had this debate. Some of you no doubt have heard about it. So the story goes like this. Madison's done with the Constitutional Convention, September 17, 1787. Jefferson is in Paris, right? Jefferson's not part of the Constitutional Convention. Madison and Jefferson are close friends, but Jefferson is Madison's mentor. So Madison sends the Constitution off to Jefferson and asks him what he thinks about it. Jefferson writes back and says, I like certain things about it, I like particular things here or there, but the one thing I really don't like about it is that there's no sunset clause. Now, he didn't use the term sunset clause, obviously, but he said there's no mechanism for the Constitution to run its course and a new Constitution be drafted. And so he gets in this conversation with Madison about enduring constitutions, and Jefferson thinks that every generation ought to write its own constitution. Fascinating idea, right? And Jefferson's all about math and stuff, and so he writes back and he says every 19 years a new generation comes into being, that we ought to write new constitutions every 19 years. Madison says, Tommy, no. The Constitution needs to endure over a long period of time in order to build up the necessary reverence for it to be stable, right? We all know that that Madison won that debate. But how fantastic would it be if Jefferson had won that debate and we had a history of constitutional conventions throughout history? Right now, the only way you can get there is you have to have 2/3 of the states, or 3/4 of the states agree to meet in convention. That's what Article 5 says. That's a lot of states. There's no chance that's going to happen. So the how is you invoke the Article 5 Constitutional Convention section. It's never going to happen in my lifetime because, A, people revere the Constitution, even though they don't know what it says. How many students do you think in my 25 years at Skidmore have thought that life, liberty, and the pursuit of happiness is in the Constitution? No, it's in the Declaration of Independence. Even John Boehner stood up and waving the Constitution, and he talks about life, liberty, and the pursuit of happiness. Anyway, so why? Because we revere the Constitution. 2, because of the fact that people fear what's called a runaway convention, where if you get people in Philadelphia, metaphorically in Philadelphia, they'll go wild and create a whole new constitutional form. That's not going to happen either. Constitutional delegates are always conservative with a small c. They'll always go back to the middle. I don't think we'll have a parliamentary system or anything like that. But I do think we'd have 18-year terms for federal court judges, and I do think we would have I think we would have a one-term president, 6 years. That's the way it should be, with maybe a 2-year retention election. There's lots of great ideas out there, but ultimately, I don't think the Constitutional Convention will come about because people are fearful in the United States and they revere the constitutional text to begin with. I'd love to see Jefferson come back to life and say, let's meet in convention and rewrite this puppy.
On that note, thank you so very much for being here tonight.